Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday. So, I thought today we would go to the most popular docket, the most popular clip of a different docket. It's a YouTube judge, because that's where, they save them there. They would never save a most popular Colorado docket, because there's normally only 3 people watching. 2 of them might be me. So, I don't know what happens. I skimmed it, and, there's some fiery lawyer testimony. Well, not testimony, argument. And she doesn't give a verdict right away. She has to look over other testimony and everything. So while we're watching, I'm going to try to find. I have the case number. Well, everybody will. So I'm going to try to find the what she said, what she decided while we're watching. Here we go. This is her most popular case.
52433.
Okay, I love that color. There's this lady taking pictures or filming this on video. I love that color that her dress is.
We are resuming proceedings today for purposes of closing arguments on this file, on this petition. May I have the names of our participants, please?
Good morning, Your Honor. Todd Flood on behalf of the petitioner.
Good morning, Your Honor. Ariel Berger here on behalf of Deanne Warner.
Suzanne Wilhelm, GAL for Andrew Warner.
Michael McFarland, attorney guardian litem for Deanne Warner.
Morning, Your Honor. May it please the court, Larry Lee on behalf of Dale Warner, who's seated to my right. Dale Warner.
All right. Any preliminaries before we get to our closings?
Oh no, that's so bad. Okay, look at this camera angle. While I was skimming, I just assumed that was Mr. Brooks. Because, it's not that far-fetched that that's Mr. Brooks. And I was ready for it. I heard, not a lot, but I did hear some fiery lawyer testimony or argument, and I was waiting to see how he would respond to it. It's not Mr. Brooks. Oh, darn. Someone just took away my candy.
I have nothing, Your Honor.
I have nothing, Jen. No, thank you.
Nothing.
I'm sure you're surprised to have that, Judge.
All right. So be it. Mr. Flood, whenever you're ready.
Thank you, Jen. I had started off thinking about this for the last time since we broke, Your Honor, and I tried to come up with Dee Warner and who she is, who she was. If you go over here to Adrian College, there's 2 women. Both of them were foster kids from farmland over by the Thumb up north of Deckerville. Edie Buffett and Betty McDonald. Edie Buffett, 5'2", is in the Hall of Fame at Adrian College. Graduated right around the war. She was my godmother. Betty McDonald, parents died young when she was right around 13, 14. Foster home. Went to Adrian. The 2 became inseparable. They were amazing women. I thought they were that lost generation of women that we just don't see often And I came to find out they're all around us. It's a matter of seeing them. And that generation lost, that greatest generation, that was Dee Warner. I call her the first responder. That's what I call her, the first responder. Why do you say that? It's funny, you made a comment, Judge, it stuck in my head when Chuck Bullock testified. You know, he's more qualified or better qualified than the other people that had just testified. He's an expert fiduciary. And we had just listened to 3 people testify. And every single expert in this world always relies on facts. They always rely on the soul, the person, the human being, the heart. That first responder was what came from those 3 first witnesses. And they painted this picture of Dee Warner. And one thing that was simple and clear in the testimony from those 3 witnesses: communication, faithfulness, and always there. The love of that lady for her children, for her to like say to these kids, to this family, walk through every single one of them and say, I'm going to leave them. Judge, if you love someone, if you have a heart, if you have a soul, walk through these people. Walk through each one and say, I got to say goodbye to them. I'll leave. That's not a first responder. That's not someone that went to a massage, if you go to, and hey, I got to have my phone next to me and I got to have it on if my family calls me. Are you kidding me? That was her DNA. And that was her environment. That was the lady that was there for all of them. And there's no way she's going to leave a baby. Did you hear the testimony of the facts, what experts would testify about, what Chuck testified about? Because Chuck Bullock testified, I wanted to find out what she was like. I wanted to get to the family. And that's what he based his opinions on. Her baby girl and her were inseparable. They were together constantly. So if you're going to walk away, walk through that soul, that love. Facts dictate cases. Every time you teach a class in law school, every time you teach something with regarding to law, you always want to focus in on facts. Every single person of those lay witnesses that came up and testified, from, get this, when Amy testified, and she testifies, I don't want to be here. I got a connection to Dale because I'm the fiance of his brother. But she had the courage to get up there on that stand and said she's dead. And she said she'd do it for me. I'm willing to risk my home life because my family is connected today. But to simply say, and she could have turned a blind eye, she didn't. She didn't turn a blind eye. She said, and she turned a blind eye, always there. And what was amazing was, remember the scene? Do you remember the picture in your mind's eye when she goes there on that 24 and she picks up the child? How does she describe facts? How does she describe Dee? That fateful night, that night ultimately where it was to her demise. She says, I've never seen her that way. She's a tough woman. Don't get me wrong, she's a tough woman. She had ailments. And we'll get to those. She had migraines, headaches, back problems, knee problems. She had it all. But she's a tough woman. And I'd never seen her when she'd been crying, when she'd been watched out. I'm calling it quits with Dale. I'm calling it quits, Dale. Not that I'm leaving the world. I'm calling it quits. Never seen her like that. I know on Sunday, I'm trying to get a hold of her, she says. I'm trying to get a hold of her. She's always up. Habits, Judge, evidence, habits. She's always up on that Sunday. She goes to breakfast. She does her family stuff. What happens? What happens? Can't get a hold of her. Cal calls later on. Hey, you see my mom? I'm supposed to meet her at the diner. Right? So Amy's, that's not her. It's obviously clear. Who comes up next, Judge? And we can get into the domestic violence. We can get into the bruises. We can get into the evidence of the fact that there was beatings that took place on this woman before. Facts, but let's just go to the witness testimony of the second witness that gets into the stand. The competent, no one's impeaching her. She lost her husband. Who was there? First responder. Don't you want a friend like that? Don't you want a kindred spirit like that in your life? I surely know I do. Who's there? D. Because everybody, you lose your husband, you lose your spouse. You know, it can be uncomfortable. You know that as well as I do. It's common sense, right? So people shy away from you. Not D, first responder. Girl, I'm there for you. Let's go. We're going to lunch. I need to be out, D. Can you come take me? I got to have some human reaction and socialization. D's there. Describe D with the dog. Inseparable. How's the relationship? Very powerful. It doesn't take more than common sense to know Dee's not leaving that baby, nor this life, nor this world as someone that is there as a first responder. Go to the massage therapist. I just did the math last night, and 40 times a year, weekly massage. 5 years, 200 times. 200 times. Judge, you ever see somebody 200 times on a religious basis over 5 years? Guaranteed. It's remarkable. That's a pretty telling story. As Hopkins would say, everyone's got a story. That's a pretty telling story, right? See that person 200 times, 5 years, and talks about the bruising, talks about that, but not only did she see that person 40 times 5, 200, she also talked to her on a regular basis. She talked about life. She talked about how passionate, how raising her younger, because her children were younger. She talked about how devoted and dedicated and the habitual steps that Dee would take to be there for everyone. She was the connective tissue. As I said in the opening, the evidence would suggest or point out, if it comes out to be true, it came out to be true. She was the connective tissue to this family that brought everybody and was there for everybody. So experts rely on, judges rely on facts. Clear and convincing evidence is that for which the allegation to be true, it is clear. The United States Supreme Court, the Michigan Supreme Court, probate courts, believe it or not, have more cases for burdens of proof than any other circuit court or district court, except for getting your driver's license back. But every court, probate courts have the most cases with a burden of clear and convincing evidence. You just have to look in all the journals, and it's always in re when you want to establish that definition. In re. So what is it? Based on facts, the evidence is heavy. It's weighty. It's clear. There's no rebuttal to the evidence. What witness, what morsel of proof do you have in here to rebut the weight and avalanche of the clarity of this testimony and evidence? There hasn't been one. Now you get to, on that day, we brought in Mr. Bullock. And why? Why was Bullock so important? Why was Bullock so important? Not he established water's wet. He established the elements necessary for why this, in his opinion, Dee's dead. Dee Warner's dead. No one with her passion and her drive, as you learned about her, wants to give up her baby of business to some stranger. Her money and how she spent it and how hard she worked and how much she spent. No one wants to give that up to Chuck Bullock, he says. And every step and point he went through was that there was not transparency and there was definitely obstruction of trying to figure out where the dough rate, where the money was. And I knew I was going to get the answer. He didn't know, and you heard it. There was about $150,000 he couldn't find, and I used the phrase basically that was a pimple on an elephant's tuchus, and he said that was a rounding error. Well, we put an arrow in that, and you can button it up. And I'm not going to get into the Michigan State Police testimony at this point, but Michigan State Police trooper in charge of this case on the criminal side of the fence said, no, we found it. We found $140,000, and that was in a credit card that accounted for that money. So, but Mr. Bullock comes in. Now, it's clear in every criminal prosecution, when you prove a cold case and something similar to this in probate courts as well, you always look to the cash, follow the money, follow the money, follow the money, follow the money.
Your Honor, I'm going to object at this point. This is not a criminal case, and for Mr. Flood to allege that this is a criminal case, I think it's beyond the facts that have been produced here. This is a petition to determine death, and I would.
Well, I appreciate that. I have a lower standard, thank goodness, but I can go to the reasonable doubt, but I don't have to. I've made an analogy in this closing argument, Your Honor. The analogy is, in this particular situation, you follow cash. And here, the expenditures by Dee Warner, and you got the Yo-Yo reports, you got the expert testimony or the fiduciary testimony in his capacity as a fiduciary. That's how we qualify. He can testify and give his opinion that she's dead. But the point of it is that there has been no expenditures of money since that day of April 25th. How do you survive? Follow the money. There was no export of cash from the state prior to pay for Dee Warner to live, to survive. Follow the money, follow the facts. No money. How do you survive? Bring out and buttress that testimony with the expert that comes in, and I shouldn't say expert, I'll say the Michigan State Police analyst, who is highly educated. But Judge, the electronic footprint for which you leave, I leave, Mr. Lee, anyone in this room leaves, except if you still have a rotary phone and no cell phone, everyone has a footprint. And everything as it relates to travel has a footprint. Everything as far as what we see on cameras, from either the ring cameras, from the cameras on the road, to eye recognition, to lean information, to national information, to world information, not a blimp on the radar. What all the evidence You have all the exhibits. You've seen this first responder has never shown up in any footprint of travel. The fact of the matter is, when you listen to her and the depth in that exhibit, it's 3 pages long, and we went through all of the material that she went through. There was not one scintilla of evidence, not one piece to show that she was alive after April 25th. I held the deputy actually to last on that first day of that June date we had been here. And the deputy that came in here established for you, if you look at the statute in B and C, one of the things that it says within the statute of prima facie evidence of death is that of a missing persons report. You have it. I put it up. I put it up on the screen. I paraded it around for 3 or 4 different times. We don't, but a missing persons report is enough as prima facie evidence of death under C.
What in the world is going on? What in the world is going on? All right. Here's what I got so far. I really don't know what I got so far. Mom died. Mom gave her kids to like somebody, like, was it a someone she didn't know? And then she died. And then, or dad has the kids, but he's doing stuff to make it seem like mom is still alive, like sending texts back and forth or something. I don't understand. I'm trying to wrap my head around. He's very showy and blah, 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 but man, he sucks at telling a story, especially when there's a story like this involved. Anybody have any idea what's going on? I'm looking up this case and there's nothing. I have nothing. I do know that it went to the Court of Appeals. And I do know what happened there. They lost, but that doesn't tell us anything. Whoever loses here goes to the Court of Appeals and loses. So it doesn't really tell us anything.
Or, disjunctive, you can prove, if you don't have that, you can prove death by circumstantial evidence or by establishing the burden of clear and convincing. Circumstantial evidence, Judge, as the jury instructions, and as you have tried a plethora of cases, and as an evidentiary issue, we look at circumstantial evidence, and it's right there in the jury instructions. You can presume that it's raining outside if someone walks into the room here and has an umbrella and takes the umbrella, taps it, there's drops off, a raincoat drops off. You have enough evidence to show that it's raining outside. Although you didn't see it, although you didn't hear it, although you weren't outside. That's enough, even in the highest standards of the world, to prove. Here we just have to have clear and convincing evidence. So the deputy, I asked him, is this some willy-nilly thing you do? I mean, is this something you could just write up, don't have to get permission to write up that missing persons report? Remember his testimony? Oh, no. That goes through a higher chain. I have to make sure I get approval for that. That's why that standard's there. But what I think was telling, when that deputy was there and on that stand, and you heard him, and he was clear, and he had taken Reed test. That's the training and interviewing and an investigation of interrogation, the 9 steps he
pause. Guys, I've heard, I think, enough to know that I want to see the whole thing. I want to see the testimony. What do you think? I can just keep going. This is just closing arguments. I can just keep going, or we can start from the beginning. I don't know how long it is. There, I found it. Hold on. Let's see how long it is. $104. What? Case number 2252433. So far there's 2 videos. That's enough for 1 live stream. Oh, there's another one. So it looks like today and tomorrow. I'm definitely starting from the beginning. Abso-freaking-lutely, yes. Just want to make sure I got everything. I want to cross my I's and dot my T's, you know? I'm just searching the case number in YouTube to make sure I only get 3 videos. Oh, there's a 052433. There's another video that's 34 minutes long. I'm trying to see. I need to start at the beginning. All right, that's the beginning. Got it. I think. This is only 40 minutes long.
Has been subject of some argument on the
1852.
All right, the record should reflect I've had a chance to talk briefly with the attorneys in the back on the issue of the witness that has been subject of some argument on the record so far today, and I believe they may have some comments to share that will resolve that issue. Would you like to begin, Mr. Flynn?
Yes, it's
Nope. Okay. I'm looking at her docket. I'm looking closely. Unless it's backwards, because I sorted.
5433 ML.
Right, we're back. The record should reflect that I did inform Mr. Lee before we were on record that
Struggling. There's just I can get some testimony, but this is the first video in her stream of this case. So which means we missed a little bit of testimony, but that's okay. We're just about to see just the closing arguments. So I'm going to keep playing from here. We still have like 3 or 4 videos to go.
It's my understanding at this time, well, let me just quickly give background. Judge, the only reason I brought in a rebuttal witness was because on the last day, Friday, before the hearing was to start, or Tuesday, whatever it was, before the hearing was to start, we received reports from our colleagues that, in essence, objected to agreeing with the declaration of death. It is my understanding, speaking to Mr. McFarland, he is satisfied that that by clear and convincing standard from the testimony that's taken place, that in this court, that he is withdrawing that report, but he's going to need a few minutes to lay out his report. But with that agreement, I'm not calling the rebuttal witness to his report. Again, I also understand counsel is going to also opine that lays out the factors, Ms. Wilhelm, that lays out the factors of death. And I don't want to speak for her, but after laying out those factors of death that have been established by the experts and others in this case, she is satisfied as well, but she leaves that decision to this able court, and your decision she's going to abide by. But I don't want to speak for either one of those two, but that's my understanding. Therefore, I'm withdrawing. It's also my opinion, but I will address after this witness the motion to strike.
All right. Would you like to respond, or would you like me to confirm with our other counsel as to the representations made by Mr. Flood?
I'm in agreement with what Mr. Flood has said. I was in the back and I listened to everybody, and they confirmed the position that he just put on the record. And if the court would like to talk to each of them, that would be fine.
All right. If we could have you to the podium, please, Mr. McClellan and Ms. Wilhelm. And Ms. Berger will go to you.
All right, I'm watching one that's a little older. It's only 34 minutes long, so it's quick. But oof, oof, oof. We gotta start here, guys. We have to. You'll see why.
All right. Welcome, Mr. Colderman.
Sorry, I was watching it at very high
Would you like to
speed.
put your appearance on record?
Good afternoon, Your Honor. John Polderman on behalf of the successor conservator Charles Bullock.
Thank you. We're on record today, as you're aware, I'm sure, to review the error in the calculation of credit for time served as it relates to Mr. Dale Warner. Says he was given credit for 8 days as a result of we didn't do the calculation in-house. They do it across the street. So when they looked at the file, apparently what happened was they saw that he had done 8 days on contempt and saw contempt again and gave him credit for 8 days on the civil contempt towards the criminal contempt, which was obviously not appropriate.
Wait,
So
what?
today's hearing is to review that issue and to
He's got contempt of court for a civil case and a criminal contempt of court. And they gave him the wrong credit for the wrong contempt charge. What?
hear the attorney's recommendations. I wanted to clarify it for the record as to what happened. And then secondly, to allow the attorneys to be heard on any arguments that you may have as far as what should be done to remedy that at this point. Secondly, Mr. Head has raised the question of the stay, the automatic stay that's directed by the statute when there's an appeal for purposes of 21 days. I also have the motion for reconsideration. He's requested a stay past the 21 days. I had articulated that effectively I was going to make a ruling on the motion for reconsideration as well as the issue that was up for today. There is no automatic hearing on the motion for reconsideration. So I think that catches you up. Mr. Head, would you agree or disagree?
Yes, as long as we are acknowledging the fact that there is a statutory stay. Yes.
Yes, for 21, yes. You cite 600.867. I have read it. Yes.
Just clarification, I think Mr. Head has withdrawn his motion for reconsideration. That's what I heard.
I don't know if you, is that what you want to do?
Unless the court's going to set aside the judgment of contempt.
The motion for, I'm just going to cut, I'm not going to allow you to do that because I've already got an order on it. So I'll issue this today and you'll be able to take that with you. And if the Court of Appeals doesn't like it, I'm sure they'll let me know.
Okay. So if I understand, Your Honor, you want us to still make a record or at least preserve arguments related to this 8-day potential issue. Okay. Well, aside from the stay, there's a doctrine called credit for time erroneously at liberty. And that has been recognized in several states, including the state of Michigan in People versus Lewandowski. That's 237, Mishap 612. It is acknowledged and recognized in the footnote in that case. It's also been recognized by the 1st, 2nd, 3rd, 5th, 6th, 7th, 8th, and 9th and 10th circuits in federal court. The doctrine is essentially coming out of the common law, and it states that a convicted person is entitled to credit against his sentence for time that he was erroneously at liberty, provided there's a showing of simple or mere negligence on behalf of the government, and provided that the day in the execution of the sentence was of no fault of the prisoner. That's what happened here. Essentially, that's what happened in the Lewandowski case, which refers to other cases from other circuits, where a prisoner is erroneously let out of the jail or a prison through no fault of his own. In other words, if he didn't escape. That's essentially, the government is stopped from playing cat and mouse with him and putting him back in jail. And he receives credit for that time that he's erroneously at liberty, as long as it's through no fault of his own. So under that doctrine, this court, should it be so inclined, and I know Your Honor has not set forth what your opinion is or what your intentions are, but if this court was inclined to make the attempt to reincarcerate him for that reason, this court cannot do so under that doctrine. Aside from that doctrine, there's waiver and estoppel. There's several.
Is he telling her what she's not allowed to do? That never works, dude. Why don't you just tell her to calm down? Judge, calm down, chill, relax, chill, leave him alone. Try that instead. Lawyer, sir.
Several courts have held that, again, when a government is stopped from playing cat and mouse, this is a direct quote, the government is not permitted to play cat and mouse with a prisoner, delaying indefinitely expiration of his debt to society and his reintegration into the free community. And again, that's from People versus Lewandowski, which I already cited on the record. It also was citing Dunn versus Keohane, which is 14 F3D 335.
Sorry, I thought you guys were joking. Another Smith, is it really your birthday? Happy birthday. In my head, you just had a birthday. I just said happy birthday to you like 2 weeks ago. So I thought you guys were all just, Bobby says, happy Easter or whatever. I thought you were joking. Happy birthday, another Smith. I love it when you come here. I do. There goes my camera again.
Out of the 7th Circuit Court of Appeals. The decision to release Dale here was not this court's, it was the jail's. Whether that was erroneous is immaterial for the purposes of our discussion here today. In addition to the waiver and estoppel theory and the time for erroneous at liberty theory, it's also a violation of Mr. Warner's constitutional rights, both under the United States Constitution and the Michigan Constitution, to reincarcerate him at this point that he's been let free after serving a portion of his sentence, after the court found that he was in contempt of court. More specifically, it would be a violation of Michigan Constitution, Article 1, Section 16, and the 8th Amendment of the United States Constitution, which both of which prohibit cruel and unusual punishments. And under the Michigan Constitution, it's cruel or unusual punishments. The federal Constitution is and. The idea of reincarcerating Dale is abhorrent, quite frankly. And if not shocking to the conscience, I don't know what is. There's nothing more cruel or unusual than releasing an inmate, then waiting 2 weeks after he reintegrates with his minor child, and then saying he's got to go back because somebody at the jail messed up.
Oh no, there's things that are more cruel and unusual. Toe touches, for example.
So that would certainly be unusual. I'm sure nobody in this room's heard of that. And my 15 years of practice, I've never seen or heard of anything like that. So because of the fact that it's unusual, it's unconstitutional under the Michigan Constitution. And it's also cruel and unusual under the federal Constitution.
Because it's unconstitutional.
There have been some courts that have opined on that
unconstitutional.
issue. For example, O'Brien versus Saginaw County, 437 F sub 582 out of the Eastern District of Michigan from 1977. The court said in determining whether the conditions of confinement of convicted persons constitute cruel and unusual punishment, the courts have increasingly viewed the effect of the incarceration on the individual. So the prison conditions should not threaten a person's sanity, physical or mental health. And certainly releasing somebody from jail and then requiring them to go back after a period of time would certainly affect their sanity. So for all of those reasons, in addition, Your Honor, once there's been a valid sentence, the court cannot amend a valid sentence once it has started to be served. The court simply just doesn't have that ability.
Dude, stop
And that
telling
is
her.
under
Look at
a court rule. And that is, I believe, that is MCR 6.429. The court may not modify a valid sentence after it has been imposed, except as provided by law. And again, there's no law that permits the court to amend its sentence or to reincarcerate Mr. Warner after he's been released from jail. Additionally, the credit for time served.
There's no law that the judge is allowed to reincarcerate him after he's been let out of jail, guys. Judges can't do that. It's against the law. It's unconstitutional, therefore it's against the Constitution, he says. That was his argument.
Is determined by the jail. I'm not sure of a specific statute or court rule that has a uniform rule. I know that different jails have different credits that are applied for good time, and that's an issue that was that's in play here. And finally, MCR 7.208 provides that once a claim of appeal has been filed, the trial court may not amend or set aside the judgment or order appealed from. So there cannot be any amendment to the sentence at this juncture. So aside from the fact that these proceedings are stayed, the court does not have the ability to reincarcerate Mr. Warner at this juncture. And we would ask for a ruling on our motion for a stay pending the outcome of the claim of appeal that we filed, so that we can get that ruling and we can present it, and if it's denied, we can move the Court of Appeals for a stay pending appeal. Thank you.
Thank you. Mr. Folderman, would you like to be heard on this issue?
Yes, Your Honor. A number of things. One is the Court of Appeals
okay.
has jurisdiction upon.
Hey, Mr. Folderman, it's very difficult to understand you. You're breaking up a little bit. So I don't know if you could, hopefully you're safely pulled over and not actually moving at this moment. I think we'll have to ask you to. It's muffled. We'll come back to you in a few minutes then, once you've been able to find a safe place that you could maybe stop for a few minutes. Mr. McFarland?
I'll be at the courthouse in 5.
Your Honor, this is not an amendment of a sentence. This is actually carrying out a sentence that was given by this court. These sites that I've heard, I haven't heard any site that's a Michigan site. I could be wrong, but these seem to be federal sites, federal court. They could be used for persuasion, but we're not mandated to follow those. So by this reasoning, if you have somebody, I'm not saying this is this case, but if you have somebody convicted of murder and they are released, I find it hard to believe that Court of Appeals or Michigan Supreme Court is going to say this person is out free, that their time has been served. It's cruel and unusual punishment. When given a life sentence, they don't expect anything. They should expect to be released sooner. Dale Warner likewise was given a some certain sentence, Your Honor. There was a certain amount, there was a certain time. He had counsel. It was quite clear. We don't have any transcripts to indicate to the contrary that the court was ambiguous Matter of fact, it was very clear. Does Mr. Warner have a responsibility, or at least an ability to say, you know, I understand I was in court, I shouldn't be released as early? That's a question. None of these cases that were cited, although I don't have copies, they haven't been right with me, but I don't believe that any of these cases deal with the jail's policy on releasing early or not. I think it was just a miscalculation. This is not a new or an amendment. This is an existing order. I think the court had the ability to issue a bench warrant as soon as it discovered that. So this is not something new. We're not halting something. There's already an order. He spends the time in jail. Probably could be clarified by a bench warrant, but the court is allowing counsel to order. I do not believe it's stayed by the appellate process, Your Honor. And that's my position.
Ms. Berger. Yes, thank you, Your Honor. I am in agreement with Mr. McFarland on this point. I also do not believe that these proceedings are particularly stayed. I've reviewed the court rules and I can't find anything that exactly pinpoints to this type of ruling that's been made in the past in a probate proceeding. And in that regard, I defer to the court. In relation to the issue of the 8 days that were not served by Mr. Warner, I think that it's very relevant and very pertinent to know that, by my opinion, which will be evidenced by pleadings that will be filed in this court very soon, that Mr. Warner has continually been in violation of this court's order while he was erroneously released. I do not have those ready to be filed today. Otherwise, they would have been presented to you before today. However, there are several incidences where...
No, she's wrong. They're both, all the lawyers are wrong. They're all wrong. This judge does have the ability to put him back in jail if he did not serve his sentence. But we all know 100% that once a person is incarcerated, the jail calculates the time and the jail chooses when to release. And the judges don't ever interfere with that at all. So it sounds like what happened here, he was incarcerated for 2 different contempt of courts, and he did some time, and then the jail released him. But he still owes more time. And she's saying that he's in contempt of court for being out of jail. Or, no. Yeah, he's in contempt. He violated the order when he left the jail. No, he did not. He just didn't. He left the jail because they released him.
He is attempting to operate business through the farm, where he is directing others to violate the court orders through himself and at his direction. And I believe that, in addition, I believe that his absence from this court today is further evidence of, I suppose, his inability to follow the court's order. If Mr. Warner would have been released and we wouldn't have any of these issues, if literally new information about other vehicles that are owned by the estate or in part by the estate wasn't servicing within the last week, I would probably have a different position. Is it unfortunate for Mr. Warner that he may have to go back and serve those 8 days? Sure, it might be, but it's also unfortunate that he literally cannot help himself from violating these court's orders over and over again. So I'm asking that he be remitted back to jail, that he be ordered to serve those other 8 days. That I would ask that there's a finding that this is not an amendment of a sentence, that it's just carrying out of a valid sentence. And maybe by not ordering him back, that would be an amendment of your sentence. And because there is an appeal filed, we can't do that. So I think your only option, Judge, is to remand him back to the jail. Thank you.
I also agree with Mr. McFarland. I agree with Ms. Berger
as well. I also looked and tried to find case law and other law that would be on point here as far as the stay, given the fact that the motion for reconsideration was filed, gives the court an opportunity to correct or change or do anything that it wants to do, and then an appeal gets filed later. So I was thinking that no, would not be stayed in that circumstance because the court's going to have to rule on the motion. I defer with Ms. Berger to your Honor's judgment, and you'll know what to do on whether or not Mr. Warner should go back for 8 days. On behalf of Angelina Warner, I have to say that no, he should not go back. She was delighted to have him home. She was surprised, as we all are, because she wasn't expecting him for another 8 days. But she just really, it'd be very hard on her, devastating, judging by her reaction to seeing him when she came home that day. It would just be extremely upsetting for her, for him to go back for 8 days. That said, I leave it to the court's discretion, for the court's judgment. Thank you.
I think Mr. Holderman, did you want to?
Yes, Your Honor. I'm actually in the courthouse parking lot. I was able to make it here, but I would agree with what Mr. McFarland has said as far as this not being an amendment of the court's order. It would be actually just carrying out what the court had already ordered. And on this issue with the Court of Appeals having jurisdiction, MCL 600.308 provides that the Court of Appeals has jurisdiction of all final orders. The fact that the motion for reconsideration is still pending means that there is not a final order of the court at this time. So I would submit to the court that there's actually not a stay on this proceeding today, and the court should enforce its order. The fact that someone was released early does not negate a valid order of the court. And I guess if the court is still concerned about that issue, I think we should have a chance to respond in writing to these cases that Mr. Head has cited. I don't know that any of them are directly on point or speak to criminal contempt, which is a violation of the court's order and affront to the dignity of the court. And the court has the ability to ensure that its orders are enforced and carried out. So in short, there is no stay. This court has the jurisdiction and authority to enforce its orders. There's nothing cruel and unusual about the Lenawee County Jail. That's not what's before the court today. And it's certainly not an amendment of this court's order. As Ms. Berger said, if in fact the time were shortened, that would be an amendment rather than enforcing it as written.
Thank you. Go ahead.
Thank you, Your Honor. With all due respect to Mr. Polderman, there is actually a court rule directly on point. That's MCR 7.208. That's the authority of court or tribunal appealed from. And that says limitations, subsection A. After a claim of appeal is filed or leave to appeal is granted, the trial court or tribunal may not set aside or amend the judgment or order appealed from, except by order of the Court of Appeals or by stipulation of the parties. So,
Okay, that's good because they're not trying to set aside it at all, sir. They want the exact opposite. They want it to be carried out.
there's also criminal contempt is a crime, and therefore an order finding a party in criminal contempt of court and sanctioning the party is a final order from which a contender may appeal as of right. And that's in Ray Maroon, 295 Mishaf 312 from 2012. So this, but because there's been a claim of appeal filed from a final order, it's very clear that a judgment of contempt is a final order. And because we have moved to withdraw the motion for reconsideration, even if the motion for reconsideration were to somehow render a final order not a final order, which is not the case, but even if it did, we've moved the court to withdraw. But that's not what the court is going to do. I understand the court's going to issue a ruling anyhow denying it. Regardless, that order is going to be entered one way or another. And the claim of appeal has been filed, and therefore this court no longer has jurisdiction to do anything with respect to that order, especially when that the statutory is in place. The issue that this court may have with respect to Mr. Warner not serving what this court believes was his full sentence is between this court and the jail. It is not between this court and Mr. Warner at this juncture. He was out for not a full 9 days prior to the claim of appeal being filed. And after that, now he's been out for a full 15 days. So he should receive the credit for that he deserves under the doctrine of erroneous time and liberty, which is recognized by the state of Michigan and People v. Lewandowski, as I cited. And for all the reasons I've otherwise said. The other issue is with respect to what Ms. Wilhelm indicated. It would be detrimental, it would have collateral effects to the Warner family, especially young Angelina. And it's certainly not fair to her that the jail decided to, in this court's view, release Mr. Warner early. This court knows from collateral proceedings, from other proceedings, the detrimental impact that Mr. Warner's incarceration had on Angelina, as was previously expressed in the minor guardianship case from her counselors, from the guardian ad litem, from the Department of Health and Human Services. So if this court were so inclined to believe that it does have the authority to reincarcerate Mr. Warner, I hope that this court would take that into account and consider the overwhelming and overriding collateral consequences of such a ruling. But again, for all the reasons I've stated, I don't believe, with all due respect, that this court has that authority at this juncture.
I don't think I know him.
I would be remiss not to mention, while I was not here for the prior proceedings, Mr. Warner was jailed for violating a civil court order. He was not jailed for a violent offense. He was not jailed for assault or a domestic assault or a battery or some type of a violent crime, some type of a drug crime, some type of a crime with a victim. There was not that type of an issue here. And while I was not present for those prior proceedings, and forgive me, I know that I don't know the entire history, it's surprising to me, because I do practice in criminal defense, that Mr. Warner was jailed for such a length of time when I have seen, even just today, numerous dozens of criminal defendants that are charged with violent crimes that are sentenced to less. Just the court using its equitable powers, I would hope, would factor that in if the court does believe that it does have the authority to reincarcerate Mr. Warner at this juncture as well. Thank you.
All right, as it relates to the request to stay, I appreciate you bringing to the attention of the court MCR 7.208 because it does clarify, I think, in part, some of the decisions that are being submitted to the court today. For example, subsection D indicating probate actions, that the probate court retains continuing jurisdiction to decide other matters pertaining to the proceeding from which an appeal was filed. There is no amendment to the opinion that the court previously ordered. This is properly considered certainly something that pertains to the proceedings from which the appeal was filed, but is not addressed in any way, shape, or form by the record. The court is also allowed to look at defects in the record under subsection C. There's also the fact that this motion for reconsideration really concerns the appeal. It has not been addressed, which would mean that we do have effectively an incomplete record for the Court of Appeals to review. And it does raise issues that will be addressed by the court in part, and those will be obviously very important for the Court of Appeals to consider. So for all those reasons, the court does have the authority to rule on the issues that have arisen today, including, of course, on the request for stay, which is denied. I do not think in this particular action, especially where we have the litany of examples of disregard for the court's authority by Mr. Warner up to this point, and apparently potentially continuing, that it's appropriate to allow the proceedings to stay. That creates an unreasonable barrier for those that have been appointed as conservator and attorneys to be able to properly adhere to their fiduciary and legal obligations to the estate and those that they represent. Further find that the ruling on the motion for reconsideration is appropriate to complete the record and to make a decision on the error that was made in calculation of the credit that was given to Mr. Warner. I'm not going to reincarcerate Mr. Warner. Part of the beauty, I believe, in living in the United States of America is that we do have the opportunity to look at issues of liberty, and when in doubt, we should look at them in the most civilized way as possible. In this particular situation, he certainly should have had that additional 8 days. He may, in fact, be subject to the court's proceedings again in the future, according to what I'm hearing today. So on one hand, I think it's appropriate to close the door on that issue to honor the liberties that we all adhere to and uphold in our country, frankly. That was cited in many jurisdictions on the federal circuit. And so I think there's plenty of authority there. And I also don't believe that it serves the interests of Angelina Warner. And I also don't believe that it was part of the intention of the court to put Mr. Warner through another arrest and booking process that was not contemplated by the original order. So we will allow him to remain outside the confines of the Illinois County Jail until and unless there are issues that arise in the future. We'll close the door on that particular chapter. And finally, the court's order after the motion for reconsideration will also be issued today. And there will be an evidentiary hearing set on effectively what is the request for a Ginter hearing. So if I could ask you all to look at your schedules, I'd like to look at some dates and times for that.
I would ask for a finding of fault be placed on the jail. Specifically in your order, I'd like to preserve that for the record. I would also like to get that order in writing. I don't have a client. I've said that 100 times, she's not here. But I do know that if she were here, she would want the people responsible for letting Mr. Warner out of jail erroneously held accountable. And I don't know what will follow, but I'm asking for that written order today.
That's the judge in a probate court. I think you need to talk to somebody else, not her. If she wants criminal actions taken, she can go to a prosecutor. If she wants disciplinary, she can go to the jail's warden or whatever, or higher than that. But this is a judge of a probate court. Why would she ask for that?
frankly, I don't want to say that it's simply the jail. All of us sitting here today in this room had the ability to calculate that appropriate release date and to make sure that that was communicated effectively to the jail. Asking our jail personnel to differentiate between civil contempt and criminal contempt under the same case file number was understandably out of the ordinary for them, frankly. So I think that as much as I would love to say that it is simply their fault, I think that we all sit responsible in some part for the miscalculation. And I just want to say that, frankly, I'm glad to see that the error is made on the side of liberty rather than on the side of incarceration. That's part of, again, the reason why we have the benefits of living in this country.
Jeez, this judge is goat.
I appreciate your frustration and your request, Ms. Berger, but I'm going to deny it for those reasons.
Thank you, Judge.
Anything else?
That's fair.
Okay, all right. So on the effectively what we're referring to as the Ginther hearing that was raised in the motion for reconsideration, I have Friday, December 22nd, or then I have to go into January. Any preferences?
I have court closed on December 22nd, Your Honor.
Great. Then I can clear that whole day. January it is.
He's annoying.
I can give you a,
I'm going to be annoyed no matter what he says.
well, let me ask you this. How much time do you think you're going to need, Mr. Knight? How many witnesses do you anticipate?
I can think of at least 6, so we're probably gonna have, it's probably gonna be a lengthy hearing if our motion for stay pending appeal isn't granted by the Court of Appeals by that time. I think the court should at least allow the Court of Appeals that time to rule. So I think January would be more appropriate.
I would not, and that this is probably going to appear presumptuous, so I apologize to our Court of Appeals in advance. However, I have seen in other cases that for purposes of the Ginther hearing in particular, even if they granted your motion, they would be asking me to have that hearing anyway. So I would prefer to simply schedule it and get it done rather than awaiting their directive on that point.
Understood, Your Honor.
So how about Friday, January 19th for starters?
Judge, I'm sorry, I'm out of the country.
All right, when are you back?
I'm back on that Sunday. I'm out the 18th and 19th.
I can give you a backup date on the 22nd, 23rd. And give you those 2 days as a backup to a bench trial. Is everyone clear on those 2 days?
I am.
That works for me, Your Honor.
All right, so
I am, Your Honor, I do have a pretrial, but it is at 8 o'clock in the morning on the 23rd. That should be over now.
so if we start at 9, would that
That
accommodate
would be
that?
fine. I'm sure I'll be finished by then.
All right, very good. So we'll start at 9 a.m. each day, January 22nd and 23rd. I would ask that, your witness and exhibit list be filed by the end of the year. Should be easy to remember so that we can have a look at that and determine whether or not that's going to be enough time. Previous to that, are you available for a pretrial conference on that on Friday, January 12th at 9?
Yes, Your Honor.
Can I ask the
Yes,
time
sir.
on the 22nd, Your Honor?
9 a.m. each day.
Thank you.
9, 9, and 9. The 12th, 22nd, and 23rd is what I'm suggesting.
Yes, the 12th, January 12th does work for me too, Your Honor.
At what time are you considering on the 12th, Your Honor?
9 a.m.
I'm available.
Any other?
Enough. Enough with the times. Enough. All right. The next one is 1 hour, 13 minutes long. And it's not this one. And it's not this one. So, this is the next case. And I see something interesting right away, guys. Right away. I don't know what it means.
ML.
We
Right
are
there.
here today to resume the proceedings in the matter of Deanne Warner and the request to have her declared dead. May I have the names of our participants, please?
Good morning, Your Honor. Todd Flood on behalf of petitioner Ms. Bach.
Suzanne Wilhelm, attorney guardian ad litem for Angelina Warner.
Michael McFarland, attorney guardian ad litem for Deanne Warner.
Good morning, Your Honor. Ariel Berger, the attorney for Deanne Warner.
Morning, Your Honor. May Bruce Portler review on behalf of the owner.
And John Pilgrim on behalf of the successor conservator, Charles Bullock.
We also have Mr. Dale Warner as well as Mr. Weisberg available to us by Zoom this morning. I'll note that for the record. Mr. Flood.
Thank you, Your Honor.
Okay. I think Berger's the father. And just the way they nodded their heads there when she named them, I think he's on the left. Who is Weisberger? And why is he in jail? And why is he part of this case? He might be on the right.
Judge, we're going to call our next witness. And that is going to be Detective Sergeant Brewer, please, from the Michigan State Police.
Your Honor, so before we do that, I filed a motion last week, which I hope the court will hear, concerning an
Can you
additional.
step up to the podium? It's just a little hard to hear.
Yes, Judge.
We can give you that fabulous microphone too if you need it.
Oh, no. I have a loud enough voice. I can handle it.
All right, thank you.
Judge, on behalf of Mr. Warner, I filed a motion to strike a witness that Mr. Flood would like to add to his witness list. I filed the motion. I attached some documents to my motion. I don't know whether or not the court wants to entertain that motion now. I have a potential witness this afternoon that I'd like to notify if needs to be called off. I don't know whether or not Mr. Flood intends to call the proposed witness that he wanted to add to his witness list and the additional exhibit that he wanted to add, or if he's willing to withdraw that at this point, and then I'll withdraw my motion.
Judge, I understand, and I'll talk with Mr. McFarland and his colleague as it relates to their objection to the declaration of death that was filed just before we started. That's why we added the rebuttal witness. It's my understanding that there's a potential anyway that they may withdraw that objection, in which case I may not need a rebuttal witness. I'm not sure of that right now. So before I start to argue the motion of why Mr. Lieb's motion to strike is spurious, I would actually like to have the opportunity to speak to counsel.
And I propose that we table this issue and that witness till this afternoon to give you a chance to talk about it. Perhaps I'll
Sure.
have the lunch hour to give you a little extra time to talk about it.
That'd be great.
It's fine. I would like to let my potential witness know that they have a free. I would have only called him if in case I needed him, but that's fine, Judge. I'm happy to do whatever the court needs to do.
Mr. Flood, who did you say your next witness was?
I'll spell the name for you, Your Honor.
Thank you, Malta. Thank
It's on the
you.
witness list. It's DREW. 1 second. Friar's last spelling of his last name.
EREWYOR.
That first name or last name?
That's the last name. Daniel's the first name. I'll grab him. It's
Yeah.
Oh no, I'm so sorry. I'm so sorry. I'm trying to fight this cold. Taking cough medicine now.
Raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
All right, have a seat, talk right up to that microphone and give us your full name for the record, please.
Detective Sergeant Dan Drew, Michigan State Police.
Thank you. Would you spell your last name?
D. David Rewyor.
Thank you. Mr. Flood?
Thank you, Your Honor. Detective, I don't want to demote you, it's Detective Sergeant.
Yes, sir. Thank you.
Yep. And how long have you been with the Michigan State Police?
We're approaching 10 years, sir.
Okay. And in that 10-year span, have you been assigned to investigate a numerous amount of criminal cases,
Yes, sir.
including but not limited to homicides?
And other violent crimes, yes, sir.
Okay. And in your capacity as a detective, how many cases do you think you've been assigned to in investigating homicides?
We're probably over 30 homicides, sir, roughly.
Okay. I want to just go through a little bit of your history for the court and as it relates to your training and background. Can you tell the court when you first come to the Michigan State Police what your training is?
Yes, sir. In order to become a Michigan State Police trooper, you have to attend the Michigan State Police Academy in Lansing. It's approximately can range from 20 to 25-week program. Upon graduating that, you're assigned a field training position where you complete field training under a variety of field training officers that can range anywhere from 3 to 4 months. And then you're on solo road patrol on your own.
How long does that last as it relates to your first assignment being on the road?
It depends on the individual's career path. I was in uniform for approximately 6 years before becoming a sergeant, and then, well, I should backtrack, for about 5 years before becoming a detective, and then a sergeant, and then a detective sergeant accordingly.
I got it. In that 5-year span of you being on the road, you've made numerous stops?
Yes, sir.
Numerous searches?
Yes, sir.
You've obtained search warrants?
That's correct.
And during that 5-year span, you've investigated activities, both criminal and otherwise, in that 5-year span?
That's accurate, yes, sir.
And from there, you go on, you become up the rank after the 5 years. You get into the detective.
Oh, I feel fine. I don't feel sick. I just have a cough and a runny nose. Yeah. So I just took some Dayquil, and like 10 minutes from now, I'll be like back to normal.
Bureau?
That's accurate, yes, sir.
In the Detective Bureau, it's
Thank
not
you.
just something where you raise your hand and you get nominated for. What do you have to do to get into the Detective Bureau with the Michigan State Police?
My move to the detective side of the house was selection based off of my accomplishments, essentially. And from there, the promotion to sergeant is an application process, and then selection to detective sergeant is a selection from there.
You have to take a test to become a detective.
Yes, sir.
And what is that test?
That test to become a sergeant specifically, whether detective or uniform sergeant, is a combination of policies, state laws, case laws, et cetera, a compilation of those things.
So not only is it an investigation techniques, but also your competency as it relates to laws and circumstances.
Yes, sir.
I see. And then from there, how long were you after the 5-year stint into the Bureau? How long did it go until you got your next promotion? How many years?
I was a plainclothes detective trooper for maybe 6 months before I became a uniformed sergeant. Thank you, sir. And then approximately 8 months later, I was assigned to the Detective Bureau as detective sergeant.
I see. And in each situation, there is a competency requirement to get to both levels. Is that fair?
Yes, sir.
And you have to score based on merit?
Absolutely.
Okay. So in your capacity as a detective, a plainclothes detective, how many cases did you investigate? If you could ballpark, maybe too much, but if you could give the judge some semblance or some idea of how many cases you may have investigated.
That's a convoluted answer. So as a uniformed trooper, it's very possible, and in my specific scenario, that you're working similar types of cases. Does that make sense?
Sure.
So in uniform, you're balancing your patrol duties with your active investigations. What changes as a plainclothes detective is then you're not merited those patrol responsibilities. So those two times inclusively, it's over 1,000 cases, I'm sure, criminal cases.
Thank you. And then ultimately, as you've identified yourself now today as a detective sergeant, correct?
Yes, sir.
All right. You have been involved in the investigation as it relates to D. Warner. Is that accurate?
Yes, sir.
When did you become involved in the D. Warner case, if you know the timing?
That would have been in March of last year. I became involved in aiding the sheriff's department with their investigation. And then assuming the case in its entirety full-time just over a year ago in August of last year.
Okay. So we have subpoenaed through this court and with the court's authority several documents that I'm going to break down basically into 3 topics: medical, financial, and legal topics for law enforcement. Okay?
Yes, sir.
And you've had an opportunity to see the material for which we have subpoenaed, at least from the standpoint of the list of exhibits. Is that fair?
Yes, sir.
Okay. So I'm going to, and I have the medical records. So give me the medical records and the Blue Cross Blue Shield and the medical plan. That's good. Judge, I don't know what number we left off on. In my index, it says 40, I think 46, 43. But I don't remember introducing.
I have up to 37 in my index,
Okay.
and I have an exhibit 44. It was provided, looks like forensic document examination report.
Yeah. And this transcript, Judge, it says number 45, loan operating agreement.
Hey,
I
Dayquil
might be
is,
wrong.
guys, Dayquil is legit good. Look, I mean, I can breathe right now. I just took those. It's good.
You supplying an updated one?
This was from, no, I can give you mine, Judge. Thank you.
You keep that
So this
sauce.
appears to be an
Keep it.
exhibit list from transcript.
Yeah, from your, from the court, report here in the court, Your Honor.
Oh, perfect. Thank you.
Yep.
So which one, what's 38 and 39?
Judge, I'm going to go through the list at the end.
Okay.
I think I'll start just continuing from there, and if we have to clear it up at the end, that's fine. Is that okay with you?
Yes.
Thanks.
Anyone else have an objection to that?
None.
No, Your Honor.
I don't have an objection, but I would just like to see the updated list. I have a copy of the transcript from June 20th hearing. If you can just show me where it is in there.
Mr. Lee, speak a little louder, please.
Yeah, I can figure out.
I don't have an objection. I would like to just see the list. I have a copy of the June 20th transcript, but I'd just like to know where it is in the transcript so I can follow it.
It's the 4th page
Okay.
of the transcript,
Well,
or 5th page.
mine says page 6.
6? Page 6. I stand corrected.
Mr. Polderman, any objections to Mr. Flood's plan on exhibit review?
No, Your Honor.
Right, are you able to find that, Mr. Lee?
I have, yeah.
All right, so then you know what I know. There we go.
Thank you.
All right, so which exhibit are you gonna be directing us to?
Okay. I'm sorry, Your Honor.
Which exhibit should I look at?
Judge, this is going to be the health, both the Henry Ford Health Systems, the ProMedica Health Information Management. One is 47, that's the ProMedica Health Information. Henry Ford Health Systems is 48. We have a disc, Your Honor. The disc is number 40. I'm going to label it 49. That is going to be Blue Cross Blue Shield. Just for the courts and everyone else's.
Something different happened this morning that worries me way more than a little sniffle and a cough. It was so weird. There was zero pain involved. It didn't hurt at all. But when I woke up and started getting ready for my stream, like, right there, I had issues like grabbing something because my thumb like popped, like it kept popping every time I tried to bend it, and I thought, oh no, I broke my thumb, and not broke, but broke, and it's completely gone now. But it was every time I moved my thumb, it like pop, 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 and all I did was sleep. All I was doing was sleeping. So you got to be really careful in what position you sleep every night, because if you sleep in the wrong position, your body really, really gets you for it. Usually it comes with pain. This didn't come with pain at all, and it's completely gone. I don't even know what it is. What made it do that? It was weird.
Edification, just to speed things along, I'm breaking this down as I told the witness to ask him about 3 topics: the medical, financial, and the legal. The first segment is going to be about medical information.
So this is 47. There's a ProMedica Health Information Management Records Exhibit 22 in the index. This is a different one?
No, it's the same, but because I gave you page 6 there, I didn't see how that, I got basically from the court reporter, if we didn't have labeled, she didn't have labeled in there the exhibits 1 through 40. What's the first exhibit on page 46, page 6? I just gave you the page 6.
Right. Petition Petitioner's Exhibit 40, signed affidavit of Amy Alexander.
Yeah, so we didn't have in there 1 through 39 for, that was already admitted, so I guess I was trying to make this as easy as possible to make it work there.
So the first one you're gonna introduce is number 46.
I can pass off the index over, one of the copies of the index to my court reporter.
That's fine. That's a good idea.
Todd,
We're gonna go back to the original list that we passed
That
off
would be really
before.
useful.
Yeah.
Thank you.
okay.
So that contains 1 through 37.
That's accurate.
Okay. So according to the original list, like Pro Medica would be number 22.
That's what I have.
Okay, all right, that's fine. That's how we do.
That's accurate, Your Honor.
Okay. Just glad I'm on the same page.
Detective Sergeant, in your investigation, one of your missions was to determine whether or not Dee Warner was deceased. Is that fair?
Yes, sir.
And in doing so, there's a series of things you'd want to look at. Is that fair?
Yes, sir.
The purpose of looking at medical or health information is what, if you know?
In her specific case, due to her medical history and her prescription history, it would be very likely that if she was alive, she would be utilizing her health insurance for those capacities.
Okay. And did you have an opportunity to look into her medical history?
I did, yes, sir.
Okay. I'm going to hand you what's already been stipulated to and introduced of 2 documents. May I approach her?
You may.
Thank you. Exhibits number 22 and 23. If you could just read out to the court for the record what those are.
22 is Pro Medica Health Information Management.
And 23.
23 is Henry Ford Health Systems.
And in any of your examinations of those documents that provided healthcare insurance for Dee Warner, which was alive, that we know, did you find any activity within those reports that she was using health insurance?
The only initial observations I made that she was utilizing her health insurance were 2, please interrupt me if I'm getting ahead of you, sir, were 2 prescription drug charges from a CVS in Tecumseh.
Okay, and those were ultimately returned back as not being picked up.
That's accurate. It appeared that they were on some form of like an auto refill. And the 2 prescriptions were charged to her account and then days later subsequently refunded in full because they were never picked up.
Okay.
Outside of that specific transaction, we have seen no evidence indicating any use of her health insurance.
And that would be reflective within the records for which I just gave you.
That's accurate, yes, sir.
Thank you. As it relates to continuing with the medical, you want to find some proof of life. You looked at Blue Cross Blue Shield. Is that fair?
Yes, sir.
And Blue Cross Blue Shield is an insurance, obviously, very well known in the state of Michigan. Yes.
Yes.
And she had coverage with, while she was alive, Blue Cross Blue Shield. Is that accurate?
Yes, sir.
And did you find anything? And we have a disc. Did you find anything as it relates to the insurance coverage of Blue Cross Blue Shield? As far as usage or coverage?
Not after the date of her disappearance, no, sir.
What is the date of her disappearance? Why don't we just get that established?
4/25/21.
Okay. And as it relates to the coverage, you're telling this court one of the things you're looking for in proof of life is whether or not she had her ailments being taken care of.
That's correct.
tell the court if you know, and if you don't know, that's fine. I could use something to refresh your recollection. What ailments that stick out in your mind, if you may know?
D. Warner sought regular treatment for chronic migraines, neck and/or back pain. Not in the most recent months leading up to her disappearance, but she had regular counseling or therapy appointments. She saw a primary care physician. She had semi-regular dentist appointments.
Okay.
I'm sure I'm forgetting one or two, and prescriptions relating to those specific chronic ailments on a continuous usage and others.
Okay. Are you familiar with, and it's already been introduced, Clinton chiropractic records, any kind of chiropractic type treatments for her ailments? You mentioned to the court a moment ago her back and neck injuries.
Yes, sir.
And again, they were negative as far as her seeing a physician as it related to treatment for those neck and back injuries.
That's correct.
I want to go to the Michigan Head and Neurological Institute records. Those were for migraines that she suffered from, or headaches she suffered from. Is that fair?
Yes, sir.
And you, in your investigation, we subpoenaed those records. You've reviewed those records for which we subpoenaed, yes?
Yes.
And again, it showed negative, that there was no activity for those ailments with regards to her health issues, both the migraines and headaches, through the Neurological Institute.
That's correct. Yes, sir.
Thank you. You've been involved in showing or looking for people before that have been missing, yes?
Yes, sir.
And in your experience, one of the things you look for, is it true or accurate that you would check the morgues throughout the counties?
Yes, sir.
In the surrounding areas? Is that right?
Yes, sir.
And you did that based on your law enforcement training and requirements by courts. Is that fair?
Yes, sir.
Courts have actually demanded you to, or commanded you, not demanded, but commanded you to actually look for people and missing people's reports for in the morgues under their name or under Jane Doe's. Is that fair?
Yes, sir.
Okay. These are exhibits that have already been accepted into evidence, but I'm going to list them. It's, Your Honor, it is 6 through 15. So there are medical examiners for Leelanau County. You've seen the records for which we've subpoenaed in Leelanau County Medical Examiner's Office.
Correct.
And the medical examiner's office is obviously the office where autopsies are performed, or where humans who have passed go to, correct?
Yes, sir.
And in your training, as you've already indicated to the court, this is a necessary requirement to find out if someone fitting the description or identification of D. Warner would have been at the surrounding, obviously, county medical examiners. Was there any record at Leelanau County Medical Examiner for Miss Warner, D. Warner?
No.
Okay. Oh, or a Jane Doe that matched the description or was found under a Jane Doe?
No, sir.
I want to go to Jackson County, another county that's surrounding us. Did you do the same, and did you see the reports for which we subpoenaed?
Yes.
And in those reports, was there anything that indicated Miss Warner was body or remains were at the Jackson County Medical Examiner's Office?
There are no records, sir.
Okay. And Monroe County, another county surrounding us here in Leelanau, you saw the records for which were subpoenaed from the Monroe County Medical Examiner's Office?
Correct.
And again, what was your findings as it related to that?
No records, sir.
And this is both, again, for all three that we just mentioned, none under D. Warner, nor any Jane Doe missing that matched D. Warner. Is that fair?
Correct. Yes, sir.
Okay, I want to go to Washtenaw County Medical Examiner's Office. Another surrounding county here. did you review those records for which the petitioner, we subpoenaed?
Yes, sir.
And did you find any results that related to D. Warner, either Jane Doe or identification of her, D. Warner?
None, sir.
Okay, I want to go to the next, Jackson County Medical Examiner. This would be Exhibit 12. You saw those medical examiners' records, correct?
Correct.
We subpoenaed those, you reviewed them, and the results of that finding were what?
No, sir. No results.
No finding of D. Warner.
That's correct. Yes, sir.
Thank you. I want to go to Wayne County Medical Examiner's Office. You reviewed and saw the the subpoena for which we received on those records.
Yes, sir.
That would be, Your Honor, Exhibit number 15. There were no findings, or were there findings as it related to discovering D. Warner at the Wayne County Medical Examiner's Office, either under her name or a Jane Doe?
No findings, sir.
Thank you. So you reviewed everything you could find within healthcare, both prescriptions that were necessary. Yes?
Correct.
Healthcare as far as any kind of treatment that she was doing on a regular basis.
That's accurate, yes, sir.
Did you ever find in your the records for which we've subpoenaed and given that she was one to miss, based on those exhibits I've shown this court and have been introduced, that she would miss a treatment of medical care?
It was in reviewing her basic pattern of life. She may have to reschedule an appointment, but she was consistently attending treatment for those ailments on a regular basis.
Thank you. I may get back to one other medical issue, but I'm going to go to the next topic. I'm going to get to the financial area. This court has reviewed and heard quite a bit regarding finances in this case, in testimony that's taken place before this honorable court. Have you had the opportunity to review the material for which we have subpoenaed and have gone through as far as financial records?
Yes, sir.
Okay. Can you tell the court, and I've tell the court what records it is that financially that we've subpoenaed that you've looked at?
I have reviewed the forensic audit that was ordered by Mr. Holderman. I have reviewed numerous financial records relating to her specific checking and savings accounts, and numerous credit card statements related to credit cards that she utilized.
Did you look at her bank accounts?
That's accurate, yes, sir.
And in her current bank account, well, let me stop there for a second. Why is it, if you could tell the court, in your training and expertise over the many years, why is it so important for you to look at financial records and to determine whether or not someone's alive?
There's a couple different ways to answer, a couple different points I'd like to explain. So number one, if someone were to go missing voluntarily, they would need financial means to do so. So we were investigating whether or not it was possible for D. Warner to have a sum of money to essentially survive for this long. And additionally, we were looking for what was her financial status at that time. So aside from could she have left with that much money, was it possible that she was accruing that much money over time that was withdrawn from somewhere?
Okay. And
separately, I missed the point. I'm sorry, sir.
Oh, no. By all means.
Separately, her ongoing and typical spending habits. So if there was a sum of money missing, per se, can we account for that in some way that was organic to her lifestyle?
Very well. And we have subpoenaed numerous banks, credit cards, and the like. Fair enough?
Yes, sir.
And you've reviewed those records?
Yes, sir.
One of the issues that came up into this court, not only in this hearing, but in other hearings, was a missing of about $120,000. Is that fair? You're familiar with that?
Yes, sir.
And that is something that you had looked into. Is that fair?
Yes, sir.
And had gone through the work of both the conservator and Mr. Polderman's work, for that matter, to discover where there might be a missing $120,000. Did you come to find out through the work that we did and investigated where that may have been missing or not missing?
Yes, sir. The $120,000, and I'm speaking in round figures, is a little confusing in a sense that through the EO&EO report investigation, that is the number they came to that they essentially said is unaccounted for. A chunk of that $120,000 is in part some PPP money that was received through the business from the federal government. Approximately $40,000 of that 120 was in a way mislabeled, in my opinion. So they claim it to be unaccounted for. It's unaccounted for from the business perspective, but we have accounting of about $40,000 of that. So as far as I'm concerned, we're really looking at approximately $80,000 that's missing, not 120, if that makes sense.
Yes.
In reviewing simply two credit card statements, a collection of two different credit card statements for Victoria's Secret and K Jewelers, we were able to account for approximately $71,000 in cash payments made by D to those two stores, specifically on those credit cards. So in short, we're missing approximately $80,000 just from two different entities. We're accounting for about $71,000 of that.
So
I just hate when I misplace my $80,000 like that. I mean, I guess I always find it in the end, but I hate when I misplace it.
the court, if you're doing the math here, you're telling the court there's a missing amount of about $9,000 total.
Currently, yes, sir.
Correct.
That part of our investigation is ongoing. The challenge of accounting for cash is if you go to a Coney Island and spend $10 a day, there's just not going to be a record of that, right? So it's hard to account for every place that a person can spend cash.
Very well. And the credit card,
Isn't this Michigan? Okay. Geographically, I'm stupid. I just am. But isn't Coney Island in New York? Did he just say she might go Coney Island? These people are in Michigan.
credit cards that accounted for that. And I do have, Your Honor, and I will, it's an additional exhibit, but it is the transcripts that were taken in the case before you of Sherry Coswell. That explains this. I'm going to add that on to the exhibit list as another additional, because it was sworn testimony taken by all the parties in this courtroom except for me, that explained that a jeweler missing funds, or how she spent the money, I should say.
New Jersey. New Jersey.
So the bottom line is, Your Honor, I'm going to be moving for this transcript to be introduced into evidence as an additional exhibit, and I believe that will be.
They're both the same.
Let's check with Ms. Kudrow.
New York, New Jersey.
She's got any advice for us on our next exhibit? Whatever you got.
I've got strange numbers. I have 1 through 37 in the books. I have number 40, affidavit of Amy Alexander, and then number 44.
Your Honor, with close indulgence, may I speak with Mr. McFarland, Ms. Berger, and Ms. Wilhelm? I'm not sure that they were, you notified of that deposition?
I was there.
You were there. Okay, I withdrew that. Thank you. I withdraw it.
It says who the parties are that are there.
I will grab it. What, 45?
Judge, it's the last exhibit that I left on the day I was here. So whatever that number is, that was the last one, page 6 that I gave you.
They're both the same, Malta. You're fine. It's the
And you have
general
these
area,
duplicates for what's
not
already in
Michigan.
your list.
No, not this exhibit, Judge. This is the transcript.
All right, so we have,
I'm proud of you,
that would be
Zach.
number 46 then.
Thank you, Your Honor.
Objections?
None.
None.
No objection, Your Honor.
None.
I want to get to this case. Thank you. Thank you. I apologize, Mr. Alderman. Give me the
All right,
page.
and again, this is the deposition, which deposition?
Transcript, Your Honor, of the name of the person. I'll spell it. Sherry Caswell, Caswell.
Just spell the whole name, please.
Yep, I'm sorry. Sherry. Last name is spelling is Caswell.
Exactly, Crystal, exactly.
Thank you, Your Honor. I just want to stick to K Jewelers for a moment, if I may.
JK, you nailed it.
Detective Sergeant, you did some work on the credit card payments that she paid cash for, correct?
Yes, sir.
And you came up with the amount of money that was used to pay those credit card statements via cash, correct?
Yes, sir.
Oh my God, guys. It just hit me now. I just realized that there are no children involved in this. This is the first case I've seen in front of her that didn't have children involved. But there's a guardian ad litem. Anyway, are they saying that after she died, stuff was bought at K Jewelers?
If you can hand me a label, please.
So apparently they never found her, right? She just went missing. So they're declaring her dead.
There was something else as it related to, if I understood it correctly, in our subpoenas and documents, along with testimony taken from a representative of K Jewelers regarding some jewelry that Ms. Warner did or didn't pick up or left behind. Is that fair to say?
Yes, sir.
Can you tell the court, first, the spending habits, if you remember or know, as it related to Ms. Warner when she was alive, what her spending habits at K Jewelers were like?
In my recollection of the record, sir, is there would be semi-regular transactions, the bulk of which would be a concert of cash and credit card payments, and then the occasional, let me back up, a transaction and purchase made with a concert of cash and or use of the credit card, and then subsequent cash payment for the credit card balance itself. But on $71,000 over the course of years, it was regular activity for her.
Listen, if you ever see K Jewelers on my credit card receipts, then I'm someone else is using my card. Call the police. Especially
And
thousands
what did you
of
come to
dollars.
find out as it relates to any jewelry that may have been left behind?
It appeared that that Dean had purchased a piece of jewelry, but had never picked it up from the store anymore.
I'm going to hand you, may I approach, Your Honor?
May.
This being exhibit number 28, 28 being the exhibit of the K Jewelers reports. Did you have an opportunity to review those reports in your investigation? And that's what you were speaking of.
That's correct, yes, sir.
Thank you. In your investigation that was taking place, we had looked at, and it's exhibits 26, 27. Basically it's your credit bureau reports. You had an opportunity to review that material as it related to the credit bureau reports. Is that fair?
Yes, sir.
Tell the court what the credit bureau does as a tool, first of all, in your investigation. Why is it helpful?
So my interest in the credit reporting bureaus would be if Dee had utilized credit cards that we were not privy to, and or initiated loans or some credit activity that would have occurred after her death.
Fair enough. And based on these reports, what was it that was discovered in these reports?
We discovered absolutely no activity that would indicate that she was alive.
Also, is it something where Experian or Equifax or TransUnion, the three main hubs of credit bureaus, there are some others, but the three main hubs, that there was no, in your investigation, user of those, of her identification anyway, as it related to taking out credit in her name in another place, if you know?
That's correct. There was nothing to indicate that.
Okay.
Actually, sir, I'd like to go back to that.
Sure.
There was a small business loan that was in part taken out in her name, but we have verified that that was not her action. If that makes sense.
Absolutely, and I have that SBA loan that I wanted to talk about, or a small loan that you're referring to, and for which there was discussions here last time we were in court about a power of attorney. Are you familiar with that?
In this specific case, that power of attorney, yes, sir.
Okay, and we had testimony from an expert in this courthouse that that power of attorney was forged with regards to Dee Warner's name. Are you familiar with that?
I am not familiar with that testimony prior to you just telling me, no, sir.
Okay. Is it your understanding that an attempt for this transaction you speak of was done by someone other than Dee Warner?
That's my understanding, yes, sir.
Based on your investigation?
That's correct.
And obviously subsequent to her death of April 25th, 2021.
That's correct.
Thank you. And what was the loan for which you're speaking of? Is that the SBA loan?
That's correct, yes, sir.
Thank you. And I want to say, and I don't have it right here in front of me, but it was approximately $1.5 million.
That's my understanding, yes, sir.
Thank you. Other than the TransUnion reports, the Equifax, the Experian, there was a couple other financial issues that came into your purview. And we discussed, and I don't necessarily know if I had you indicate to the court, there was approximately $65,000 left into a bank account. Is that right?
In a collection of accounts, yes, sir.
I'm sorry?
In a collection of bank accounts, yes, sir.
In a collection of bank accounts. And there are two banks here, exhibits 18 and 19. Those are both of them. Okay. Judge, this is a big box here.
I have a list, I have a copy of all your exhibits, remember?
Yeah, I know. I just want you to know that this is the exhibit. I don't know how you,
Which exhibit? 18 and 19?
yeah, this is the Premier Bank and the credit union, TLC.
Yeah, correct.
He had a choice with the quilt. He could either have it up to cover his boobs, but then it would not cover his feet. Or he could have it down at his waist and it would cover his feet. But just like ladies in a bathtub, we have to pick where the hot water goes because it doesn't cover everything. Our knees are cold, our feet are cold, or our boobs are cold. That's the way the quilt was, but he used it as a lap blanket, like when he was gaming and stuff, so it was fine.
Okay.
I don't have those on our exhibit list.
Yeah, you did. It's on the index. 18, 19.
This binder alone is exhibit 19, as far as I can tell.
This was
It
provided
is
by
a
your.
collection of accounts.
Like read it.
This what went out there, but this exhibit.
That I'm utilizing what he provided to me on its flash drive, so.
We also sent it over via hard copy. It's been given to everybody. It's the index for which I announced and went through in the opening statement.
I'll see if I have it.
So I got extra copies.
Okay, that's fine.
Thank you. So exhibit 18 and 19.
I'm still desperately trying to find out what the hell's going on in this court case. So they're not in jail for murder. Well, they might be in jail for murder. I don't know who that second guy is at all. Most likely, he's in jail because of contempt of court again, right? Because remember, the last hearing, she said she might have to revisit contempt of court based on what she heard. So it's possible he's back in jail because of contempt of court. But remember, he had two. He had a criminal contempt of court, and he had a civil contempt of court. He was supposed to do X amount of days for both. And I think it might have just been 8 for each. The jail got confused. The jail let him out in 8 days because they thought he only had an 8-day order, not 2 8-day orders. But he didn't show up for court last time. So he could be in there for that. Now we have this $9,000 missing. Okay? And it, that could have been cash payments here and there, blah, blah, blah. Or he could be in jail for that. We also have the, what was it, $1.5 million loan that she took out. And I don't know anything about that yet, but he could be in jail for that. Or he could be in jail for murder because they never found her, I think. I think they never found her. But this second guy, they're not telling the story very well for the judge. I don't know what's going on. I guess that's how probate works. It's just so, she has that great big binder of documents she has to read, and then she'll know what happened.
If you could just label those for me. Those are the two banks, Premier Bank records and TLC Credit Union records. Again, that's where you basically in a consortium found approximately 65 grand.
Correct.
And do you remember the activity prior to April 24, April 25, 2021?
Yes, and to explain a little further, the collection of accounts I'm referring to was both in her personal name, the business name, any account with her name on it. So whether it was a company account, an LLC account, et cetera. So there were several. So the activity on those is a reflection of what it was for, whether it's the business account or her personal, et cetera. But there was very consistent, very regular transactions on all the accounts, including the ones that had her name on it solely.
Okay.
Up into the date of her death, which then there was no activity in those accounts essentially.
And I will get to findings on that, but as I understand, you're saying regular activity and then all of a sudden it stops.
The stopping activity was specific to accounts that she solely owned. Obviously, the company accounts continue to have activity as a regular course of business without her.
Gotcha. Okay. As far as
Excuse me.
Yes.
If Mr. Flood's office could provide those, I'm looking through the hard copies of the exhibits. Exhibit 18 and 19 are not what he's reflecting in hard copy form. So I'm not objecting to the exhibit itself, and I just like to see him while he's going through.
I'll give him like an extra copy, Your Honor.
I have the flash drive of the exhibits that was provided with my copy. I'm happy to pass this down to you.
Be great.
Thank you. Grab second, please.
Nice, Terry. That sounds delicious.
Other than that, as far as D. Warner is concerned, and I've done the medical now, and we've gone into the financial, you've explained to the court why financial is so important. Other than the accounts, the activity for which is lacking in her use of credit and the like, what other information gained through the subpoenas and banks and the like that we've given you have you reviewed to indicate Ms. Warner has not used, since her death of April 24th, any of her own personal money, if you know? In other words, what other evidence is there that we've shared with you that indicates she's dead as far as financial concerns go?
The only other thing we have not covered, sir, is, I guess in summary, there was a collection of liquid cash she had access to that was, let's say hypothetically, she did leave. I would find it hard to believe that a person would leave, $60,000+ in an account if you're leaving forever, right? So separate than that, we have found no evidence to support that she had some other large sum of money in cash, liquid somewhere else that she would have taken with her. If that's what you're asking.
Yeah, that's what I'm asking.
Okay.
Nope. Darn it. We already went over time because I was wrapped up in trying to figure out what the heck's going on. All right. We're going to continue tomorrow. Monday morning. That's what tomorrow is, guys. All right. Yeah. Today's Sunday. So I have off tomorrow. I love when I say that. I'm going to start OJ. And then I'll see a lot of you tomorrow. I hope that you guys have a great day. Thank you so much for coming out this morning. I appreciate it. I really, really do. Bye, guys. Have a great day.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guarantee.